proceeding in the matter of Fivaz and Marlborough Knightsbridge Management Ltd.
Yes, good morning.
Good morning, my lord. I appear on behalf of the appellant in this matter. My learned friend Mr Grant appears on behalf of the respondent.
Yes.
As your lordships will be aware, this appeal concerns the question of whether the respondent, replacing the entrance doors to two flats which he holds as a tenant, has breached the terms of the leases under which he holds those flats. And as you'll be aware, the context in which the first instance court, here being the FTT, was asked to answer that question was an application brought by my client under Section 168 of the Commonhold Leasehold Reform Act of 2002.
Yes.
That section is concerned with the landlord's right to forfeit a lease in the event of breach of a tenant covenant other than a covenant relating to the payment of rent, payment of service charge, or payment of administration charge. And its effect is to control the timing of a Section 146 notice, 146 notice being a precursor to the exercise of right of forfeiture, and Section 168 controlling the timing in that you cannot serve the 146 notice until either you've had an admission of breach by the tenant or a determination of breach by the court, the FTT or the Upper Tribunal, the LVT in Wales, or by an arbitral tribunal pursuant to a post-arbitration agreement. The application, when it's brought, focused on two clauses. That's clause 3.4, which may generically be referred to as an alterations covenant, and clause 4.5, which was a tenant's covenant to comply with regulations that were set out in a schedule. The case concerns two flats, and necessarily it concerns two leases. However, each lease is materially in the same form, albeit not identical. The leases are the same for each flat within the building. The FTT record being told that at paragraph 7 of its decision, and that hasn't been challenged. Whilst the current leases were granted in March 92 for a term of 999 years, the landlord and tenant covenants under which each are held are subject to minor variations which are not relevant for present purposes, those terms that were contained in earlier leases granted in the 1970s. The two flats are flats 131 and 120, and respectively they were granted in June 1972 and November 1978. The clause that we say, the focus of the case on which the focus is directed, is clause 3.4. Perhaps for convenience, if we look at the lease for 131, which is in the supplemental bundle at tab 5. The clause is mirrored in the lease for 120, a copy of which is at tab 6. The clause is found at page 49.
Thank you. There we are.
So the recital to this clause found on the preceding page, which is the tenant's covenants, the tenant hereby covenants with the lessor as follows. So in clause 3, we include clause 3 subclause 4, which provides that the tenant covenants not at any time during the said term to make any alterations in or additions to the demised premises or any part thereof, or to cut, maim, alter or injure any of the walls or timbers thereof, or to alter the internal arrangement thereof, or, and this is what is critical for present purposes, to remove any of the landlord's fixtures therefrom without first having made a written application in respect thereof to the lessor, and secondly having received the written consent of the lessors thereto, and paying the fees of the lessor and any mortgagee and their respective professional advisors. The focus is on that part relating to the landlord's fixtures for reasons that will be explained in argument, but effectively following a decision of this court in the case of Bickmore and Dimmer. So there's a prohibition, but it's a qualified prohibition. It's subject to landlord's consent.
Yes.
And it's common ground, as a matter of fact, in this case, that the respondent did not seek and did not obtain my client's consent prior to the removal and replacement of the doors. Now, the respondent says the doors were replaced in 2014. There is no finding as to the time when my client first had knowledge of their replacement. And that is because, in relation to the alleged breach, the respondent makes no allegation of waiver. Thus, the timing of my client's knowledge is not relevant to the question of breach.
And there's no suggestion that the door was in any disrepair or otherwise not unfit for purpose.
There's no evidence of that.
There's no evidence anywhere as to the circumstances which led to the installation, to use a neutral term, of the new door.
My lord, that's quite right. It had been suggested, and I think there's a recording of this to this effect in the Upper Tribunal's decision at, which is in the bundle, it's principal bundle at tab 5.
Yeah.
And paragraph 48, which is at page 69. So what is said here, this passage is concerned with the argument that's raised in the respondent's notice that where you have replacement, there is no removal.
Yes.
But in paragraph 49, you'll see it said the appellant, and the appellant there was the respondent in this court. Contended was entitled to replace the doors with other doors that clause 4 imposed a covenant to renew the demise premise, that in doing so he was simply complying with his contractual obligation. That's not being said in this court, and there is no evidence to suggest that clause 4.1, which is, if I can conveniently refer to as the tenant's repairing obligation,
Yes.
was engaged. So just pausing there, whilst it is right that the argument as to whether there can be a removal when you have replacement is the subject of respondent's notice, that argument recited in paragraph 48 isn't.
Right. So we have to approach the case on the footing that the question arises in the same way as it would, or indeed perhaps did, just as a matter of personal choice on the part of the tenant, that he'd rather have a front door of his own, well, one that he has chosen rather than one which formed part of the premises when he moved in.
Yes, and that has some relevance in this respect, is that where there is an improvement is always viewed from the perspective of the tenant. So, as your lordship said, there's the choice of the tenant to do something, then it's viewed from the perspective of the tenant. Where there's improvement, then a qualified covenant is further qualified that where consent is subject to consent, the consent is not to be unreasonably withheld. That's section 19.2 of the Landlord Tenant Act 1927. So it's not without control, it's not without further qualification.
Yes.
There's a prohibition subject to consent, but that consent itself is qualified. The consent is not to be unreasonably withheld. Just whilst perhaps for a moment indulge me on the question of the background, you may have seen from the paperwork that the background to these proceedings was my client's desire to ensure that all flat entrance doors provided sufficient safety. What I say, what follows now, is really just to meet a point that was made at the very end of my learned friend's skeleton argument at paragraph 35, which is in the principal bundle.
Sorry, can I just go, before you get into that?
Yes.
I'm still trying to get my head around what you said earlier about clause 4.1. And it might be helpful if we actually look at it.
Yes, Lord.
So page 51 in the supplemental bundle. So it's a covenant throughout the said term to repair, maintain, renew, uphold, etc. Now, you can't repair something that doesn't need repairing. Well, why can you not renew a door even if it doesn't need repairing?
So that argument focuses on the question of whether renew imports into the clause something different to the obligation to repair. So in my skeleton argument, I addressed that with reference to the case of Collins and Flynn. In the authorities bundle, this issue as to where in a repairing obligation you have to find the verb to repair as well as the verb to renew is treated in textbook of Dowding and Reynolds on dilapidations of modern law practice, paragraph 428. And if it would be convenient, we can look at that passage now. But in summary, it is that it's generally considered the word renew, as found in a repairing obligation, adds nothing to the verb to repair.
Well, maybe it's just making explicit the point that if something is sufficiently out of repair, it may actually need replacement rather than...
So the analysis in Collins and Flynn is that inherent is almost inevitable in any exercise of repair that there will be renew. I think the example was put in argument that perhaps not with loosening a lock on a door, But the justification or the analysis in Collins and Flynn is that because repair encapsulates renew, renew doesn't add anything to the word repair. Would it be convenient, my lord, to look at that issue legally now?
Well, I don't want to take you out of your course, so whenever convenient.
Thank you. The point I just wish to address by way of opening and part of the relevant background is what my learned friend said at paragraph 35 of his skeleton argument, which is in tab 3, page 54. Which is that there was an acceptance by my client that the replacement doors provide adequate fire protection. And a similar point perhaps is found in the Upper Tribunal's decision, which is potentially misleading, at paragraph 4 of its decision, which is at tab 5, page 60. Where it said in the second sentence, it's not in dispute that the new doors were compliant with all relevant fire regulations and were entirely fit for the purpose. That statement was factually incorrect for this reason. As it reads, that appears to suggest that it's accepted by my client that the new doors were compliant with all relevant fire regulations and entirely fit for the purpose. As a statement, that was factually incorrect because it had been consistently said by my client throughout this litigation that he just didn't know.
Well, I mean, that point was raised as a ground of appeal, and permission to run it was refused by my lord on my right.
It was, and it's really because it's just the justification for raising the point was the concern from my client, and it might be said that there had been an acceptance when the doors weren't fire safety compliant. But I think it was clarified by the Upper Tribunal.
It's a complete non-issue, as far as
Yes,
yes,
exactly.
There was also an issue when it was the matter before the Upper Tribunal as to whether the first-tier tribunal had identified with sufficient precision the clause that was said to be breached. I don't believe that to be an issue raised in this case. I think we're all clear that it's clause 3.4.
As I understand it, I mean, it's now common ground. The only issue is whether there has been a breach of clause 3.4, and the only bit of clause 3.4 relied upon is the reference to fixtures.
Indeed, so it is
So it's a very narrow issue in
of
that
contractual interpretation.
Yes. And it's common ground also, I think, that there's no question of breach of the alterations covenant on the basis that the scope of that covenant is confined to matters which are, so to speak, part of the permanent structure.
Correct. Correct.
And at any rate, in that context, the front door is not regarded as structural.
Which was common ground before.
Which is common ground. Yeah.
Yeah.
So we get the result. I mean, if the Upper Tribunal is right, then this particular switch of front doors isn't caught either by the alterations covenant or by the fixtures covenant.
Correct.
Well, that just may be one of those things. So again, which brings on back to where we begin, which is it all turns on the construction of the relevant provision.
It does, and there's two elements to it. So it is what's the meaning of the words landlord's fixtures and whether they capture the entrance doors, but then secondly, whether the verb to remove is used in that context.
Yes.
Is with or without replacement.
Yeah.
And it's right to say, necessarily because we're here, we're not construing any definitions clause. There is no defined meaning of those words.
Yes.
In relation to its decision that the removal and replacement requires required consent, the first-tier tribunal expressed itself at paragraph 19 of its decision in this way, which is to be found in the main bundle at tab 9. It's paragraph 19, which is at page 97. They're about halfway down. There's the word partway through a sentence. Reads the removal of the front door, and the replacement with another does, in our finding, require the consent of the landlord. It goes on. This seems logical because one would expect a landlord to want to maintain some commonality of doors of the property. In light of the recent problems with regards to fires in flats, certainly an intention to ensure that doors provide sufficient fire safety. By requiring consent to such items, it enables the landlord to control whether the doors meet the safety requirements, as well as providing suitable alternative to ensure that the ambiance of the building is maintained. What might be added to those considerations is the following: is that over the term of a long lease, and when the leases were granted in the 1970s, it was for a 99-year term. It might be expected that the tenant would wish to change or alter fixtures, objects that were affixed to the premises, either with the intent of replacing the object with a substitute or permanently removing them. However, in the event of a removal, then at the termination of the lease, the landlord will be getting back something that is different, to that which formed part of the demise at the time of grant. Because in the case of replacement, the demise will be returned with an object which, whilst perhaps of a similar type, is necessarily different. And in the case of there being no replacement, then the demise will be returned without the thing itself. So again, in such circumstances, or to use the language of the FDT, it seems logical that it's expected that the lease will seek to strike a balance between the competing interests of the landlord and the tenant, the flexibility of the tenant to make change, but on the other hand, ensuring that the landlord, in effect, is consulted before that change takes place. What we submit is that those are relevant matters of context. I'm not suggesting that they're matters that justify reading into the lease provisions that cannot properly be said to be found there, but they are matters that inform the interpretation of the words that are used in the lease.
Yes.
And for the reasons that are common ground, it's not that control is not to be found in the general alterations covenant, because that is directed or limited in form to structure. So where is it found? It is found in the prohibition, the control over the removal of landlord's fixtures. So and is that contextual reading consistent with the text itself? So a starting point might be relevant. It is relevant to ask what might be said to be the ordinary and natural meaning of the words landlord's fixtures.
I mean, do you accept that it is, at least to some extent, a term of art? Or do you say we simply have to look at it as though we were never heard of it, as it were, heard of the term fixtures in the landlord and tenant context before?
Well, I accept that if one can find consistency in the case law that identifies what it means, that might be of assistance. But I would suggest or submit that it's difficult to do so.
But that doesn't mean it's not a term of art. It just might mean it's one which the courts have found it rather difficult to define.
I accept that the passage which I cited from the judgment of Lord Justice Sedley and Rees and Peters about conventional expressions and conventional expressions used in conveyancing more particularly.
Yeah.
And that was an example where this court, Lord Justice Chadwick, had adopted an interpretation of certain words given by the court followed an interpretation of words that had been given by Lord Justice Chadwick, I think, in Preston Nicholson. And the court in Rees and Peters said, well, we don't find there's any assistance in relying on previous cases. But I say it is a hallowed term, to use the expression in Elite Stone and Morris.
Quite. It's the sort of word you expect to find in a lease.
The point comes down to this. Is it your submission that we simply ignore all previous authority and approach the words of this lease in the abstract, say within their own context? Or do you accept that it is to be assumed that the person who drafted this lease was perfectly well aware of the fact that the expression landlord's fixtures was a term of art and used it for that reason?
The latter.
Right. Thank you.
That is consistent with my written argument. I don't distance myself or my client from previous case law, insofar as it's possible to identify a meaning of those words from that case law.
Yeah, thank you.
So you have the Rees and Peters point, but this argument is picked up as early as in Elliott and Bishop, which concerned the interpretation of a yielding up provision.
Yes, well, on that, the authority which is cited in both skeleton arguments instance, and is in the bundle of authorities, is the first instance decision which was partially reversed on appeal. So that's not very helpful, is it?
Well, Lord, my understanding is it certainly isn't.
So what's in the bundle, and this is what's cited in the skeleton arguments, is the decision of the Court of Exchequer in 1854. It subsequently went to the Court of Exchequer Chamber in 1855, and a unanimous court partially reversed the first instance.
Lord, if I have no explanation, I apologise.
So, can't treat what's in bundle of authorities as having any authority.
I apologise. I repeat my apology, and for the inconvenience it causes. In which case, I won't dwell on.
I mean, I'm not sure it matters much because, of course, there's plenty of subsequent authority which it might be thought is slightly more pertinent anyway.
Well, moving then perhaps to Leasehold and Morris.
Sure.
So that case concerned the question of whether a bungalow had become part and parcel of the land, and the relevance of that the analysis was to the status of the occupier, because if it's part and parcel of the land, as distinct from a chattel, the occupier had the benefit of rent act protection. The issue in that case was framed by Lord Lloyd at page 690G, which is in tab 14 of the authorities bundle.
Yes.
Where it said that the issue for your lordships is whether Mr. Morris's bungalow did indeed become part of land, or whether it has remained a chattel ever since it was first constructed before 1945. His lordship went on at paragraph 8. You'll be noticed that in framing the issue for decision, I avoided the use of the word fixture. There are two reasons for this. The first is that fixture, though a hallowed term in this branch of law, does not always bear the same meaning in law as it does in everyday life. In ordinary language, one thinks of a fixture as being something fixed to a building. One would not ordinarily think of a building as a fixture itself. So pausing there, there is some helpful indication of what one thinks of as fixture as a matter of ordinary language, something fixed to the building. And it echoes, or gives some resonance to what was said later, subsequently by Lord Justice Sedley and Peters and Rees, that even hallowed terms can be understood differently.
I mean, Lord Justice Sedley can't have been saying one should pay no attention to existing case law on the meaning of a commonly used phrase, can he? I mean, if he really was saying that, I would respectfully disagree, because I think one has to begin, as I think you accepted a few minutes ago, by looking at the existing learning, albeit, of course, recognizing that the particular context in the lease one is dealing with may show that any normal meaning is not what the draftsman actually had in mind.
Yes, that I do accept. It's just a cautionary note rather than...
Yes. Yes, I mean, if it's simply a cautionary note, that's fine. It's just sometimes it gets pushed a bit too far, I think, to a proposition that you should treat every single document you ask to construe as, so to speak, in a vacuum, without regard to earlier decisions on identical or very similar wording, which is commonly used and recognized as being a common phrase in the relevant area of law one is concerned with.
Yes, no, I don't press it that far.
No, thank you.
But is it your case that in the context of these leases, the expression fixtures is used in a different sense from that in which it was conventionally used as a term of art?
if one takes the understanding of its expression, as, say, Boswell and Crucible Steel, perhaps look at that case. Just pause it because it echoes, I think, what was said. Well, my submission echoes what is said by Lord Lloyd here at the Leadstone and Morris about how, in ordinary language, one thinks of a fixture as something fixed to the building.
Yes, I mean, as you say, if that emerges from the judgments in Boswell,
it does, because you start with the original structure.
Yes.
What the reasoning in that case was that the windows were so fundamental to the structure of the building that really there was no building if the windows weren't
Yes.
there. So it couldn't sensibly be said. It's almost like it's an exercise of the iterative process of testing your interpretation to see whether it makes commercial sense.
absolutely. Sorry.
I'm sorry, I still don't understand what your answer to my question is, because as I see it, you could be arguing in one of two propositions, and I'm currently not sure which. So one proposition you might be arguing for is to say, yes, of course, fixtures is a term of art. It has the following meaning, and that supports my case. So that might be one case you could be arguing. The second case you might be arguing is to say, yes, it has a recognised meaning as a term of art, but when you look at this particular lease, you can see it has a different meaning. Now, which of those two is your case?
Well, not wishing to be unhelpful, I don't believe that they are. I would submit they're not necessarily mutually exclusive, because it begs the question as to what is the if the meaning of landlord's fixtures is, as I say, it's concerned with original structure per what was said in Boswell. Things affixed to the original structure, then I would say that is entirely consistent with my case that an entrance door is something that is affixed to the original structure that is the building. So that would be consistent and would be using the expression landlord's fixtures in its conventional meaning. If, however, it means something else, which would on its interpretation exclude the entrance doors, then and my submission would be that it's a different meaning.
So do I understand that you are arguing the case in the alternative? Your first proposition is that the conventional meaning of landlord's fixtures as a legal term of art does not cover the doors. If you're wrong about that, in the alternative you say that in the context of this particular set of leases, these two leases, it means something different.
So it does include the doors as in its conventional meaning. That would be my primary submission.
Yes, sorry.
Yeah.
So you put your case firstly on the basis of the conventional meaning, and in the alternative you say it means something different.
If its meaning is not if its conventional meaning is not as I submit it is per Boswell and Crucible Steel, such that its meaning it would be to exclude the entrance doors, and I say that is not the meaning that was intended for the purpose of this lease.
Thank you.
On that footing, perhaps appropriate to look at Boswell and Crucible Steel. So it's tab 11 of the authorities bundle.
Yes, thank you.
And it was concerning the interpretation of a repairing covenant, which is recited at page 120 on the second page of the report. So the tenant's obligation was to, at the top of page 120, was to keep the inside of the demised premises, including all landlord's fixtures, in good repair. And the landlord's covenant repairing obligation was to repair the demised premises with all necessary reparations, except such repairs as are hereby agreed to be executed by the lessee. And the glass windows fell out of repair, and so the issue was who was responsible for the repair, and that then turned on the question of whether the windows were a landlord's fixtures. The physical layout of the premises is most fully explained in the judgment of Lord Justice Banks at page 121. see 3 lines down from the plan which was put in at trial, it appeared that this ground floor, which was a total height of 11 foot, was enclosed in brick walls to a height of 3'6", supporting plate glass windows 7'6" and occupying width on the Borough Road frontage 29 feet out of total width 33 feet, set in Lancaster Street 23 feet out of total 25. So that we have to deal with a building, the ground floor of which was so constructed that its walls, to use what's perhaps the better expression, lodgers to Bramwell and Ball and Plummer, the skin of the house consisted to a large extent of the glass. And then over the page, the judgment on this issue of Landlord Just Banked, page 122. The lessors contended, just above halfway down the paragraph at the top, page 122. The lessors contended that the windows are landlord's fixture and that the liability consequently falls on the lessees, but I don't think that contention can be allowed. It is impossible to say that the windows such as these, forming part of the original structure of the house, are landlord's fixtures.
Yeah.
The judgment of Lord Justice Scrutton is beneath that, on the same page 122, third line down. Premises consist of a ground floor used as a warehouse and offices, and it appears from the photograph and plan which were put in that the greater part of the outer sides of the building consist of plate glass windows, that the premises are practically enclosed in a wall of glass. And then, about halfway down passage of Lord Justice Scruton's judgment there, the meaning of the term tenant's fixtures is well understood, but I've always had difficulty understanding what is meant by landlord's fixtures. But at all events, it seems to be clear that the expression cannot include a thing which form parts of the original structure. It must be regarded as confined to things which have been brought into the house and affixed to the freehold after the structure is completed. If these windows can be treated as landlord's fixtures, the whole house would be a landlord's fixture. And then the final Lord Justice Atkin, his judgments at page 123. Again, there's a brief reference to the structural layout of the building. The question is whether, 4 lines down, the question is whether the covenant included the plate glass windows which form the greater part of the external walls of the house. About halfway down through the judgment, the sentence beginning, a fixture.
Yes.
A fixture, as that term is used in connection with a house, means something which has been affixed to the freehold as an accessory to the house. It does not include things which were made part of the house itself in the course of its construction. An expression landlord's fixtures, as I understand it, covers all those chattels which have been so affixed by way of addition to the original structure, and so were affixed either by the landlord or if by the tenant under circumstances in which they were not removable by him. As these windows were part of the original structure representing the walls of the house, so that without them there would be nothing that could be described as a warehouse at all, they cannot come under the head of landlord's fixtures. If they could, every brick used in the building would be a landlord's fixture.
I mean, the argument against you, shortly, is really that that reasoning on a fair appraisal of it covers front doors in much the same way as it covers windows, isn't it? I mean, you can't sensibly build a house without a front door. And from that point of view, it's not a landlord's fixture. It's part of the original structure of the building itself.
I think 2 points emerge. Firstly is that what is, I would submit, is very clear is it's the nature of the windows in this case, and that the size of the windows, if one looks at the relative size of a building with 11 foot high, 3'6" brick walls, 7 foot something, as a plate glass window, the focus is very much on the consequence of the window being very much part of the wall, and the conclusion that without that window, there would not. This is how Lord Justice Atkin put it. Without that window, there would not have been a warehouse. Because what you would have been left with was, in effect, a dwarf wall of 3'6".
Well, to be sure, it's clear that all 3 members of the court regarded the size of the windows as making it a clear case. But if one looks at the reasoning, why would it have made a difference if the windows had been smaller?
In the case of I can see that. I think in the case of windows, I would submit that I would recognise the position is arguably different to that of a front door because the window completes the external wall. I think it's still difficult to say that a building without a window is not a building. Cannot be said. I don't believe it can be said that a warehouse without a window is not a warehouse.
Well,
I don't think it.
I mean, a dwelling house without a front door, one might ask the same question. I mean, what use is that, one might say?
Well, it's still usable as a flat. You still, I mean, because if one puts it in the terms of the use of the use of the flat can still be used as a dwelling. It can still be used as a dwelling without a door. So what does the door afford? The door affords privacy
And security.
and security, physical security, but not legal security, because there's still a right to exclusive possession of the dwelling.
Why is usability the test? As I read Boswell, the distinction that the court was interested in arose from the fact that the lease distinguished between who had to repair things. That was all. And it made sense to say, the lease itself said that the building has to be repaired by the landlord and the fixtures have to be repaired by the tenant. It wasn't anything to do with any of the other considerations that you're talking about. What they thought was it made sense that the building had to be repaired by the landlord, and so the glass, because it was obviously what made the building a building, had to be repaired by the landlord.
But in order to reach that conclusion, it was necessary, because if one starts with the landlord has to repair the building, there was a carve-out from that, was an exception. The exception was insofar as the lessee's coming in to repair. And the lessee's coming in to repair applied to the landlord's fixtures. So exactly. It was necessary to identify how one interprets those words, the landlord's fixture, and the delineating line was, is it part of, I would submit on the judgments, is you ask yourself, is it part of the original structure? That I would submit is a consistent theme throughout the judgments, particularly found in those of Lord Justice Atkin and Lord Justice Scrutton.
Well, if I may say so, I think that's a very reasonable test at the moment. But if one applies that test to the present case, why do you say that a front door is not part of the original structure?
Because it doesn't form. Because it doesn't form part of the structure.
Well, it doesn't. It doesn't in a sense. It's not perhaps a load-bearing part of the structure in a way that an engineer might describe it. But surely, from the point of view of the person who's going to live there, it's just as much part of the structure as the walls, the windows, and all the other things that make up an inhabitable house.
That is then thinking about the meaning from the position of, say, in ordinary language, which is what Lord Lloyd spoke about in the Leasehold and Morris.
Yeah.
And he said, in a matter of ordinary language, a fixture is something that's attached to a building. What I would submit as a door is something that is attached to a building. Yeah.
But I mean, these are only very broad guidelines. And the question is, yes, in a sense, that is right. I mean, the door is separately manufactured. Somebody comes and screws it in with hinges or however else it is attached. And it started life as a chattel and then became part of the building by being affixed to serve the purpose of operating as a door. On the other hand, from perhaps a more practical perspective, you might say that a house without a door is really not a house in any normal meaning of the word at all. So from that, looked at that way, it is every bit as essential as walls and windows.
Well, if one's then thinking, because that then does bring back a question of utility, because we're talking this, and so then one thinks about sanitary apparatus, one thinks about sinks, one thinks about taps, one thinks about toilets, which would ordinarily be considered to be fixtures. They're attached to the land, they form part of the land. And my submission would be that an entrance door is closer in analogy to those items. Than to saying it is part of the building. Because they again, with reference to say the iterative process, Lord Justice Atkin and Lord Justice Scrutton, excuse the expression, stress tested the interpretation. Because if it was to be said that the windows were a landlord's fixture, it would necessarily follow in that case that the entire building was a landlord's fixture, each brick would be. So that then informs that the interpretation of a window being a landlord's fixture cannot be right, but that doesn't follow if one were to hold an entrance door to a flat within an apartment block is a fixture. It doesn't follow from a finding that an entrance door to a flat in an apartment block is a fixture, that the entire apartment block is a fixture, or indeed that every brick within the building is a fixture.
I see that.
If it's appropriate to do so, we can look at Elitestone and Morris, but I suspect it may be common ground with this, that in Elitestone and Morris there's no consideration as to what is a fixture. That follows, that's tab 14 of the authorities bundle.
Yes. And of course, Boswell is one of the cases that was cited. I can't remember whether it's referred to, it probably is in Lord Lloyd's judgment.
It is, my lord, it's
Yes.
page 690.
Thank you. Yes, sorry, of course it is, yes. So that must inform the classification which he then gives at the foot of 691. Well, in fact, he's adopting what Woodfall says, and no doubt what Woodfall says is similarly informed by the case law, including, of course, Boswell.
But in adopting that threefold classification, we've seen, he expressly disavows reference or reliance on fixtures at page 690H. In framing the question, he avoids using the word fixture, and he explains with two reasons why he does that.
Yeah.
Because of confusion as to its meaning. And so when then one comes down to the threefold classification at 691G, yes, they're separated into three items of a chattel, a fixture, and then an object that's part and parcel of the land itself. But then Lord Lloyd, in effect, marries those two, the second and third categories, to say, well, now what we're going to do is to see whether it's a chattel or part and parcel of the land. A fixture, items B or classes B and C are part and parcel of the land. So the analysis proceeds effectively on a twofold classification.
I'm not sure I quite follow that. I mean, he's surely endorsing the threefold classification precisely because there is a distinction to be drawn between fixtures on the one hand and something that's part and parcel of the land itself. So in any given case, you have to look at the facts and ask which, if it's not a chattel, which of those two categories it falls into. And if it's part and parcel of the land itself, that prevents it being a fixture. So that's why, in a sense, that's the prior inquiry, isn't it? I mean, you ask yourself, is the window part and parcel of the building? Answer, yes. Ergo, it's not a fixture. And why can't one apply the same analysis to the front door?
Because what Lord Lloyd does in that adoption of the threefold, because the threefold classification doesn't just stop at A, B, and C. There's then the combination of B and C, recognising that they're together treated as part of the land. And so there is no so in that case, the question
Yeah.
arose for determinant.
Yes, sorry.
And so that provided convenience, because the issue there was, is the bungalow a chattel or has it now been affixed to the land? So that's the binary choice that could be resolved, whether as a twofold, whether you treated it as a traditional twofold, to adopt the phrase there, chattel or fixture, or adopted a threefold, but which really it's a binary choice for the purpose of that case. Is it a chattel or is it something that's part of the land? And it's, Lord Lloyd proceeds on that basis to say because he intentionally avoids use of the expression fixture in framing the question. So by combining and that was at 690 TH, 690H.
Well, I mean, that reflects the issues and the facts in that case, which for whether the bungalow was to be regarded as a chattel or not. And once you ruled out that analysis, it didn't matter whether it was in category B or category C. So that it doesn't follow from that the distinction between categories B and C is immaterial in other cases.
No, but it does. I entirely agree with that. But it doesn't. What it does show, explains the reason why you don't find an analysis in Leakstone and Morris as to what is a fixture.
Yes, I follow that. Yes. So for that purpose, we need to go back to the other cases, including, of course, Boswell.
Indeed. So, well, we've looked at Boswell, and
yes,
don't, unless it would be of any use to propose to return to that. There is, in terms of, as regards other cases where one finds some analysis, or at least a reference to what might be considered to be a landlord's expression, there's Lambourne and McLellan. And that's at tab 9. So that case was concerned with a case of Lambourne and McLennan was concerned with a yielding up covenant. The covenant to yield up is found recited at page 269. It's to be found embedded within the repairing obligation. So the paragraph begins on page 269 as the lessee covenanted to repair and keep in repair.
yes,
The first part of the clause, as recited, deals with that obligation to repair, but halfway down you'll see and will at the end an expiration or sooner determination of the said term hereby agreed.
yeah,
So that's where the yielding up provision operates. So yield up unto the lessor together with all doors, locks, keys, bolts, bars, and then lists a number of items and things which are now or which any time during the said term hereby granted shall be fixed, fastened, or belonging to the said messuage and premises or any part thereof. And the question that was asked was whether machinery that had been installed by the tenant was captured by that obligation to yield up.
yes,
And it was held that it did not. And the reasoning was that the fixture, was that the machinery was not a fixture captured by that clause. There was no express identification in the listing of machinery, and so the question was whether it was captured by any other fixtures. And the reasoning was an application of the doctrine of justum generis, and you can see that at page 276, bottom of 276, passing on to page 277, taken from the judgment of Lord Justice Vaughan Williams.
yes,
And when we come to the word fixtures, I think that looking at the covenant as a whole and bearing in mind the proper application of the doctrine of justum generis, we ought not to hold that the removable machinery of this kind comes within it. And the reason for that was the classification of the items within the list. And that can be found at page 274. And again, still taken from the judgment of Lord Justice Vaughan Williams, about a quarter of the way down the page, it says, looking first at the things particularly enumerated. So looking first at things particularly enumerated in the covenant, ending with the word shelves. So that was the list of the items that we looked at page 269. It is not easy to say that any one of them, and it might not be of such character that under the ordinary law, if not altered by agreement, would not be removable by the tenant. They are all such as generally described as landlord's fixtures. That is not a happy expression, for it is sometimes used in another sense, namely as denoting fixtures of which the landlord will take an inventory at the commencement of the term. But I am using the expression as meaning fixtures which under the ordinary law, by reason of their attachment to the premises, the tenant would not be entitled to remove as against his landlord. So this is an example of a case where, with reference to specified items, those items were brought under the umbrella label of a landlord's fixture. And when one goes and looks at the list, one sees there the passage that we looked at, page 269, together with all doors, locks, keys, bolts, bars, staple hinges, iron pins, waistcoats, etc.
I mean, if one is going to adopt an justem generis construction, the presence of the word other is always a helpful pointer, which we do have here. All other erections, buildings, improvements, fixtures. I mean, that tends to imply that everything which has gone before falls within the same categories, which are then expressed in more general, by use of a more general term introduced by other. But we don't have any parallel to that in the present case.
But what we have in Lambourne is, because it's not using the covenant itself doesn't use the expression landlord's fixtures, it uses the expression fixtures.
Yeah.
And so applying the Justum Generis rule, what the court was doing was identifying the nature of the items that preceded it, and therefore was interpreting fixtures as being limited to the class of the items that preceded, because the machinery is fixed to the land. But it said, well, not for the purpose of this lease, because when it uses the expression fixture, it means landlord's fixtures, and I know it means landlord's fixtures because look at the items individually, separately identified in preceding it, and those are what would ordinarily be understood as landlord's fixtures.
Yes. So is there anything else you want us to look at in Lambourne?
In Lambourne, no, my lord.
Thank you.
It has been said, and it is cited in support of the proposition that doors and windows are not fixtures. It's been said that proposition is founded in the case of Climian Wood.
I see, just looking at Lord Justice Romer, he does actually refer to Bishop and Eliot. I'm not sure whether the reference is to the...
Well, so does Lord Justice Vaughan Williams.
Indeed, so does Lord Justice.
In both cases, it's the appellate's decision.
That's the appellate decision, thank you, yes. Just wanted to check that. Yeah. In fact, all three members of the court refer to it, so does Lord Justice Cuttance-Hardy. Yes, sorry, you were going to take us now to...
No, I mean, my lord, without repeating my apology, which I do repeat, but whether it be as assistance for myself and my friend to put any written submissions on the appellate decision.
Well, I don't think it matters too much because the effect of it is clearly stated in Lambourne and McClellan.
Yes.
But that was an application of the Justum Generis rule. That was what, as I understood, the reliance of Bishop and Eliot for.
Well, it's a little more than that, because if you look at, as my lord was just pointing out, if you look at what Lord Justice Romer says, bridging 277 and 278, he says Bishop and Eliot proceeded on the broad ground that where in such a covenant and lease there's a series of words which generally point to can only be satisfied by providing the things which ordinarily, as between land and tenant, would not be removed by the tenant. General words which follow ought to be limited to things of the same kind. So you're right, it is a Justum Generis, but it's within a specific context.
Yes, and then when that was applied by Lord Justice Vaughan Williams in Lambourne and McKellen, and saying, well, I identify the word, I interpret the word fixtures as meaning landlord's fixtures by reference to the items that preceded it, it sheds light on what items might be considered to be a landlord's fixture. It is said that in textbooks that Climian Wood is supports the proposition that windows and doors are not fixtures. Probably the decision of Climmie and Woods at tab 6. And the question there was whether trade fixtures passed under a mortgage of the freehold to the mortgagee. And it held that it did. The tenant's right to remove trade fixtures, it was said, did not apply as between a mortgagor and a mortgagee of the freehold. Of the judgment of Mr. Justice Willis at page 329 begins about a third of the way down of the paragraph of judgment, the sentence beginning, there is no doubt that sometimes things annexed to land remain chatteled as much after they've been annexed as they were before. The case of fixtures hung on a wall for the purpose of being more conveniently seen may be mentioned by way of illustration. On the other hand, things may be so completely a part of the land as being essential to its convenient use that even a tenant can't remove them. An example of this class of chattel may be found in doors and windows. Lastly, things may be annexed to land for the purpose of trade or domestic convenience or ornament, in so permanent a manner as to really form part of the land, and yet the tenant who has erected them is entitled to remove them during his term, or maybe within a reasonable time after its expiration. And then it goes on for a consideration as to whether the exception for the right of a tenant to remove trade fixtures applies to a mortgage of the freehold, which is not relevant for present purposes. But what was not being considered or addressed in that passage, quoted from Mr. Justice Willis, is that any distinction between a chattel or a fixture is delineating between, to adopt Lord Lloyd's categorisation, category A, and categories B and C.
Well, why is this not a good illustration of category C? And using the question of whether it's essential to convenient use of the property as touchstone.
Because it's an example of using of the assimilation of B and C as two items that are part of the land as being distinct from, to draw the differentiation between that and a chattel. So it doesn't shed light on what is a fixture. It doesn't identify what might be the distinction between classes B and C.
Well, why doesn't it? It seems to me it provides quite a workable test, which is whether something has part of the land essential to its convenient use. If so, it's not a fixture, it's just part of the land. Well, that's category, forget now which is which, category C, not category B.
I adopt this, but the submission that they didn't have reason to, or cause to consider what a fixture is point was made subsequently in Holland and Hodgson, which is at tab 7. The question was whether, related to looms, but you could see, just picking up on the point I was addressing you on a moment ago, page 334. It's taken from the judgment of Mr. Justice Blackburn. You see about a third of the way down there's reference to Climmie and Wood.
Yeah.
In Climmie and Wood, the jury had found as a fact that the articles there in question were a tenant fixture, and the finding was not questioned. Neither the Court of Exchequer nor the Court of Exchequer Chamber had occasion there to consider what would constitute a fixture. I beg your pardon, it's tab 7.
Yes, and the report we've just been looking at is it is the appellate decision of the
Yes.
Court of Exchequer Chamber, isn't it? Yeah. I wanted to check that.
Yes, sorry.
Yes.
The page is 334, isn't it? I think you said 344.
I did that, so 334. Thank you, my lord.
Yeah.
So my submission is that Climmie and Wood doesn't shed light on what is a fixture.
Well, yes, but look at what he says at 333 in the middle of the page.
So, my lord. 333, my lord.
Yes.
Yes.
bang in the middle of the page, he says, since the decision of this court in Clymie and Wood, it must be considered a settled law, except perhaps in the House of Lords, what are commonly known as trade or tenants' fixtures form part of the land and pass by conveyance of it. And that though if the person who erected those fixtures was a tenant with a limited interest in the land, he has a right, as against the freeholder, to sever the fixtures from the land, and yet if he be of mortgage or in fee, he has no such right as against his mortgagee. So he certainly regards Clymie and Wood as authoritative on the proposition of what forms part of the land.
What I was simply saying is that it's settled law as to what passes. Bear with me a moment, sorry. Yes, so what can draw from that is it's settled. Tenants' fixtures form part of the land, which would be consistent with the assimilation of categories B and C by Lord Lloyd in Elitestone and Morris. Fixtures being treated as part of the land. So it's consistent with the grouping together of classes B and C, but it doesn't shed light on what the difference is or what are the characteristical differences between Class B and Class C.
Okay.
Thank you, Will. Another passing reference. It doesn't, in my most respectful speech, doesn't add to the argument. But at tab 13, there's a copy of a case called Stokes and Costain Property Investments Limited, which is a tax case where the tax allowance should be given for equipment installed by a company, and the issue there was whether it could be said that the equipment belonged to the company. It was decided that it didn't for the purposes of the tax legislation. But obviously I'm not concerning ourselves. I'm not inviting you to concern yourselves with what does the meaning of belong or belonging to entail. But there is, in testing the proposition, page 769, the judgment of Lord Justice Fox, in consideration of whether an item might belong to an entity. It says in the middle clean paragraph, which begins "I return," about halfway down the sentence beginning, it seems to me that in ordinary usage they would not be satisfied by limited interest. For example, I do not think that one would say that a chattel belongs to X if it merely had the right to use it for 5 years, nor do I think that it's apt to use a language to say that the landlord's fixtures belong to the leasehold. He cannot remove them from the building, he cannot dispose of them except as part of the hereditament, and subject to the provision of the lease and for the term of the lease. There is a reference there to a landlord's fixtures. All it does is clarify that they're items that the tenant has no right to remove.
Yes.
So, my lord, those are the cases such as we have to shed light on what might be the meaning of the hallowed term landlord's fixtures. It's not resolved by Leadstone and Morris.
Do we get any help from the textbooks?
The textbooks cite the cases that we've
I mean, if they just
looked at.
cite the cases and don't add in anything much in the way of analysis, the answer is probably no. We're not going to get very much help.
Certainly, my learned friend and I thought that the authorities themselves were of more use than the.
Yeah.
There is a textbook which is so Aldridge's Law is at tab 2, from a learned friend referred to.
Sorry, this is Aldridge.
It's Aldridge, my lord.
Yes.
It's taken from 328, and you see nature
Yes, thank you.
Fixture is normally something added to a completed structure rather than something covering most of one wall. No surprises what that references to.
Yeah.
And skylights form part of the roof. Perhaps anonymously, doors and windows are being referred to as fixture, although ones cannot be removed. Things may be so completely a part of land as being essential to its convenient use that even tenant can remove them. An example of this class of chattel may be found in doors or windows. So immediately you think, well, that tells me the answer. But the citation for that is Climian Wood,
Yes. Which we've just been
which
looking
we've
at.
looked at.
Yeah. And then a reference to this very case, yes, in the Upper Tribunal.
We have, in the context of repairing obligations, which is where this expression is often found, we have Dowding and Reynolds, Dilapidations of Modern Law Practice, tab 3. And the page, internal page 594, pages being at the bottom, find paragraph 225.3. Under the heading fixtures. Fixture is anything which has been affixed to the demised premise of a building in such a way that it's lost its chattel nature but has not become an integral part of the land or building. For the purpose of analysis, fixtures are conveniently subdivided into the landlord's fixtures and tenant's fixtures. The expression landlord's fixtures has been criticised. There's no particular significance. What's cited there, actually, tab item 7 is the Elliott and Bishop report that we have in the bundle. It has no particular significance in the law relating to fixtures, save to denote fixtures which are not tenants' fixtures. However, it is an expression which is sometimes used in repair of similar covenants, is generally used to refer to fixtures which the tenant is not entitled to remove, either because they are annexed to the premises by the landlord and were therefore part of the demised premises from the outset, or because they were annexed by the tenant after the grant of the lease, but the circumstances are that for whatever reason he has no right to remove them.
Yeah.
So insofar as one identifies from the case law what might be or what might capture a landlord's fixture, I would say that my submission is the case law is consistent with the expression including the entrance doors.
Yes.
The Upper Tribunal assessed some of the consequences of that interpretation and looked at its interrelationship with the tenant's repairing obligation under clause 4.1. Would it be of assistance to explore those arguments?
I mean, yes, at some point, obviously, we need to look at them because here we are focusing very much on the wording of the particular lease.
Yes.
And we do have the distinction, at any rate, between clauses 3.4 and 4.1, and that the latter does refer expressly to the doors.
It does. So perhaps if I address that argument first, that wasn't one that was addressed. Sorry, yes, that argument on 4.1 was addressed by the Upper Tribunal. So the decision of the Upper Tribunal on this is at paragraph 45, which is at tab 5 of the bundle, internal page 69. So this argument would now be moving away from what is the conventional meaning of the words landlord's fixtures and testing it within the context of the lease to see whether that works.
Yes.
And so the Upper Tribunal is on Judge Bridge at paragraph 45 recited his reasoning there. And the Lordship says it's the enumeration of certain items which are then captured. We'll look at the clause in a moment, but then captured by and all fixtures and additions. So if one looks at the clause itself, which is in the, go back to the clause, the supplemental bundle. We're looking at the lease of 131, which is at tab 5, and internal page 51. So there is the operative provision of the obligation to repair, and then the identification of the subject matter of the repairing obligation, which is the following items insofar as they form part of or are within the demised premises, and then the list follows, which is windows, glass and doors, including the entrance door to the demised premises, locks, fastening and hinges, sanitary, water, gas, electrical, apparatus and walls and ceilings, drains, pipe, waters, cables, and all fixtures and additions in good or substantial repair and condition. And as I understand the argument, it is that having enumerated certain items and then met that at the end with the words and all fixtures and additions, the inference can be drawn that the draftsman intended the items preceding it not to be categorised as fixtures for the purposes of this lease. A number of points follow on. First of all, the clauses are structured differently. So Clause 4.1, there is a listing of items, which is not the way that Clause 3.4 is structured. And essentially, by in effect, what His Honour Judge Bridge was respectfully doing was treating Clause 4.1 as a defining part of a defining machinery, by defining what the expression landlord's fixtures means. The second better point, perhaps in my respectful submission, is that if one tests that, it necessarily follows that all items, the effect of the Upper Tribunal's decision is that all items that are separately enumerated in the list are not fixtures. So it would follow that sanitary, water, gas and electrical apparatus are not fixtures. In that list are also drains and pipes, which if it's necessary we can go back and look at it, but those are also items listed in Lambourne and McKellen, which Lord Justice Vaughan Williams said were items that one would consider to be landlord's fixtures. So if His Honour Judge Bridge is right, and for the purposes of this lease, sanitary apparatus, water apparatus, sinks, taps, etc., are not fixtures. My respectful submission, that cannot be right.
But what one can perhaps gather from this wording, and it's only a slight indication, is that the doors are at any rate regarded as, for this purpose, forming part of the demised premises, because the introductory words are including so far as the same form part of, or are within the demised premises, all windows, glass and doors, and then specifically mention the entrance door. So is that not an indication that for the purposes of this lease, the draftsman is regarding the entrance door as something that forms part of the demised premises? And that in turn is a pointer to category C rather than category B.
Well, no, because category B does also include things that are treated as part of the land.
Yes, but
so,
I mean, given that there is a distinction between categories B and C, and we've got to draw it in a sensible fashion,
so
why is this not a, albeit perhaps slight indication from the wording of this particular lease that encourages us to regard the front doors being something that forms part of the demised premises, and if anything, not falling within the subsequent reference to all fixtures? NB, it doesn't say all other fixtures, it just says all fixtures.
It does. It was common ground that the door formed part of the demise.
Yes.
But using addressing it in that way, then there's the slight indication that other items form part of the demise, other fixtures, insofar as they are in-law fixtures, sanitary apparatus. There is nothing, and I would respectfully submit, that says that a fixture cannot be part of the demised premises. It's not insofar as authoritative for the position, but the passage that we just looked at from Dowding and Reynolds talks about fixtures being, landlord's fixtures being items that are affixed affixed to the premises so as to form part of the demised premises.
Yes.
A further point is it's not the identical expression. So in clause 4.1, the reference is to fixtures, whereas in 3.4, the reference is to landlord's fixtures. So the word as used in clause 4.1 captures things that are not caught by clause 3.4. That would be a reason to add the word separately. So whilst items enumerated in the list may be landlord's fixtures, and I would submit that they are, it captures other fixtures that wouldn't necessarily fall within that wording.
Yeah.
You say it's meant to cover tenants' fixtures.
It would be capable of capturing that, because it's not limited to
Well,
any...
I understand
Yes.
your argument is it would be capable of it, but I'm not understanding why it makes sense for it to cover tenants' fixtures. Why would the lease have a clause in it that said that the tenant had to repair tenants' fixtures?
Once installed, it would become part of the land. Although it is removable, it still becomes part of the land by nature of it being a fixture. It's the fact that it's a tenant's fixture enables the tenant at the end of the term to remove it. So it's a question of removability rather than its status as a chattel or part of the land.
Okay.
So it would make sense to include it within there because it's capturing items that form part of the demised premises, irrespective of who brings them there. So there is, in my respectful submission, no tension between the interpretation I submit for clause 3.4 and clause 4.1. And clause 4.1 doesn't shed light on what is, or provide any limitation to what might be considered a landlord's fixture for the purposes of clause 3.4. With reference to that clause 4.1, this is not an argument that was adopted by Arnold Judge Bridge in his decision, but it is an argument advanced by my own friend and has been in the earlier tribunals, is that an interpretation that captures the doors in landlord's fixtures under clause 3.4 creates practical difficulties in the operation of clause 4.1, because it is said that in the event that it's necessary to remove a door to repair, and by that I mean permanent removal, not temporary removal, i.e. something comes back, it isn't what was taken away, then it makes the obligation to repair impractical because you need to obtain the landlord's consent. A short answer to that is that it's clearly envisaged by the draftsman that there is to be correspondence between the two clauses by dint of the use of the word fixture in both. So the adoption of the same word in the two clauses illustrates that it was envisaged that the two would operate together. To be clear, it doesn't, compliance with clause 3.4 doesn't prevent repair, it simply presents a requirement in the event that repair involves removal.
Yes.
Those were the arguments addressed to any intention with clause 4.1. Perhaps since we have clause 4.1 open, what my lord asked about the meaning of the word renew. whether that involves something different to repair, such that it can mean the installation or switching of doors. The most convenient place to look at this treatment, and I don't think either of us are inviting the court to determine what the verb to renew meaning is in this particular lease, but just to illustrate why it's an unsafe premise to try and draw meaning as to remove or any other clauses in the lease. There's a treatment of this question in Dowding Reynolds, page 92, so that's tab 3 of the authorities bundle. And internal page 92, paragraph 428. Bottom of the page, the verbs to be found in repairing covenants sometimes include an obligation to renew in addition to the obligation to repair. The question then arises as to whether the inclusion of this word obliges the covenantor to carry out works which go beyond what would ordinarily be required under a covenant simply to repair or to keep in repair. And there's reference to Collins and Flynn. A copy of Collins and Flynn is in the bundle. It's perhaps convenient to take the relevant passage from here. So Collins and Flynn, the tenant covenanted well and substantially to repair. The verb renew was included within the repairing obligation. It was argued that the inclusion of the word renew imported a liability going on beyond the ordinary meaning of repair and obliged the tenant to construct new foundations. The judge rejected this contention, his reasoning being as follows. Leave you to read the reasoning.
Yes, thank you.
Their attention is drawn to the Credit Suisse case in which it was, a different conclusion was reached. The key for the understanding of that case is in the proviso, which is recited in the quoted passage.
Yes.
So it's an unsettled, perhaps pretty usually area of the law, and not inviting the court to resolve it here, but the general thinking is that absent something indicating otherwise, which in the case of Credit Suisse was the proviso about including defect or repair, that the word or the verb to renew doesn't add anything to repair when used in the repairing obligation.
Well, there is a more basic point that one starts with an assumption or presumption that words are included in a clause for some purpose, and if the conclusion is they're purely synonymous with something else, that means that there was no purpose at all in using the word. So perhaps one is inclined to try and find a separate nuance, at least, and renew as opposed to repair, and that's what Mr. Justice Lindley is really sorry, didn't see, is doing in the passage which you've just referred us to. On the other hand, one knows from experience that conveyancers are very apt just to pile up synonyms or near synonyms using a kind of scattergun approach and hoping that something will hit the target.
Yes, the torrential style of drafting.
Yes, which is very familiar in leases and
Yes.
other conveyancing documents.
But because there is that uncertainty as to whether it does add or doesn't, it's an unsafe premise to say, well, that does enable the tenant to switch the doors or to change the doors, or indeed require them to change the doors, absent repair. Well, sorry, absent disrepair.
Even so, one can imagine circumstances where the boot might be on the other foot, with your client seeking to enforce a repairing covenant in relation to the front door, being met with an argument that, oh, it needs replacement. And then you might be saying, well, look here, there's the word renew as well as repair. So,
Well, yes, I mean, that argument does arise in connection with service charge disputes, because the landlord
Indeed.
says, well, I'm entitled to renew. I therefore am carrying out that work. You are required to pay a service charge. And the tenant, in fact, it's the tenant who then argues, well, renew doesn't add anything to the obligation to repair.
yeah. Anyway, I think for the purposes of this case, renew is a sort of interesting byway rather than something we need to focus on too much, because as you say, neither side is asking us to construe that phrase, and it's not directly an issue.
No, it does feed into my Lord Friend's argument when it comes to the interpretation of the word remove.
Remove, yes, I see that.
The other reasoning of His Honour Judge Bridge, other than the analysis on clause 4.1, touched on what he said was it was counterintuitive for a fixture to be part of the demise, and I've addressed you on that. It was then said that the paragraph 44 of the Upper Tribunal's decision was said that the absence of a door would be a derogation from grant, and that supported the reasoning for the fixture, for the door not being a fixture. I don't fully understand paragraph 44, which tab 5, 69.
Yes.
So the context in which it's said is a consideration of Boswell and Crucible Steel. You see the reference there to paraphrasing Lord Justice Atkins' judgment, sorry.
Yeah.
It seems to be, the context in which it's said is that it's to, whilst the door is not part of the structure of the building, without the door there would be a derogation from grant. So therefore, if the absence of a thing would constitute a derogation from grant, it cannot be a fixture. Seems to be the use to bring it within the judgments of Lord Justice Atkin. I mean, I have some difficulty in understanding, but that I think is my interpretation of its relevance.
Well, I think the point is being made is that the way in which one identifies a lease and distinguishes it from, e.g., a license, is that it's a right of exclusive possession, and there is no exclusive possession, it's being suggested, absent a front door. I think that's the point.
That the concept of exclusive possession is a legal one, not a physical one, which is the submission I made earlier. Because I can have exclusive possession of an unfenced field. just to be absolutely clear, we're not suggesting for a moment if the entrance door is a landlord's fixture, we have a right to remove it. That's no part of my client's case. I'm not suggesting that we have that right to remove. But the analysis doesn't really sit easily with other items that you might characterise as being fixtures. If, in order for there to be no derogation, the absence of an item means that there'll be a derogation of grant, therefore that item cannot be a fixture, then the same analysis would apply to the sanitary apparatus again. Because it would be said that the absence of a sanitary apparatus would be a derogation from grant. If the absence of an item leads to a derogation grant, it can't be a fixture, then the logical analysis is that the absence of a sanitary apparatus which is necessary for the use of a residence as a dwelling would mean that those items can't be a fixture. That I would respectfully submit is not right. It's a passage I find difficult to understand precisely as it's to its reasoning or its place in the analysis, but for those reasons, I would submit that it can't be right because it leads to inconsistency with those other items. If, as an exercise of contractual interpretation, we get to the point where there's ambiguity in the words used, then, and so there's such what might be referred to as rival meanings, then consideration goes to what might enable what is more consistent with business common sense. And those are the contextual matters which I outlined at the outset about the control, striking the balance. There is reference to the discharging the burden of proof of paragraph 46 of the Upper Tribunal's decision. I think it's contended by either of us that this is a case where there is a burden to be discharged. Yes, the legal burden is on my client to establish there's been a breach of the covenant, but there's factual agreement. It's a question of law as to what the meaning of the clause is.
I suspect the learned judge really meant no more than that. The burden is on your client to show there's been a breach of covenant.
Yes, and we fell on the question of law, therefore we question for law.
Exactly.
Yes.
I don't think he was suggesting it was like a question of fact, which one might seek to use the burden of proof as a tiebreaker.
Yes. So those are my submissions on the meaning of landlord's fixtures.
Yes, thank you.
Forgive me, Mr. Grant. I know it's. Sorry, forgive me, Mr. Fieldset. I know what you say. Landlord's fixture covers entrance door. What do you say that the term means? I've been trying to work out if I've just missed it. I think I have just missed it. Just tell me, what do you say it means?
It's something that is affixed to the structure of the premises, either by the landlord or the tenant.
And that applies to both landlords and tenants' fixtures, or that's landlords' fixtures?
So that would be.
Or in other words,
well, so a landlord. So the
Sorry, I'll shut up. Go on.
so it could be affixed by the tenant, but if the tenant doesn't have a right to remove it at the end of the lease, then it would be characterised as a landlord's fixture. So the qualification of a tenant's fixture is to differentiate between those fixtures which the tenant is obliged to leave at the end of the term and those which it's permitted to remove.
I see.
Something affixed to the structure by either the landlord or the tenant, and that's a fixture, and then if the tenant has no right to remove it at the end, then it's a landlord's fixture.
Yes. The first part, in fact, is, to paraphrase what Lord Justice Atkins said, is a landlord's fixture. Boswell and Crucible, as it happens.
Thank you.
So it's a fixture because of the annexation to the building, and it's a landlord's one because it's one the tenant can't, as it were, undo and take with him when he goes.
Yes.
Yeah.
And am I right in understanding that it's never been argued that it was a tenant's fixture? Is that correct?
That is correct. So it's perhaps quite useful to pick up on that differentiation between landlord's fixtures and tenant's fixtures when one moves into the concept of removal. because what I would say is the classification or characterisation of a landlord's fixture is something that cannot be removed. So what this lease does is actually permit something that would otherwise not be permissible, because it allows, albeit in a qualified way, the removal of a landlord's fixture. Yes, it's a prohibition, but it's of course subject to an exception. So it actually gives rise to a right to do something that would otherwise not be there. So the submission as to the characterisation of a landlord's fixture as being one that cannot be removed, as I say, is to paraphrase what Lord Justice Atkins said in Boswell, which was tab 11, page 123. Page 123, up towards just after halfway in the judgment of Lord Justice Atkins, tab 11. It's the passage, so it's taken from the judgment of Lord Justice Atkins, it's just after halfway down, the sentence beginning and the expression landlord's fixtures as I understand it. So it's the affixing of items to the original structure under the circumstance, either by the landlord or by the tenant, but in circumstances in which the tenant is not removable by him being the tenant.
Just going back to the point that we were making a second ago, what's the purpose of the clause? If we understand landlord's fixtures as being something that the tenant cannot remove anyway as a matter of the general law, what does this clause, what is its function, what is its purpose?
So its purpose is to allow something that would otherwise not be permissible. Why might that be in the case?
But it's framed as a prohibition. You're absolutely right. The prohibition is subject to an exception where there is consent. But nevertheless, it is very clearly and firmly framed as a prohibition.
Yes, but by qualifying it, it is giving something that wouldn't otherwise be there, because otherwise you might come to me and say, I would like to remove this landlord's fixture. And I would say, you have no right. The giving or refusal of my consent is absolute. So it does convey a right. Now, why objectively might that be the case? That comes back to one of the points I sought to develop in opening, which is, or looking at the context or contextualism in the exercise of interpretation, which is this at least for a long period of time. And it's conceivable that during the term of 99 years or 1,000 years, 999-year lease, the tenant will wish to change the landlord's fixtures, may wish to remove them permanently because owing to changes in lifestyle they become obsolete. And so it strikes that balance. It gives to the tenant something which it wouldn't otherwise have, but yet gives some control, or a say, or a exercise characterised as consultation in the process. Just before I leave, what I've looked at how Lord Justice Atkins...
Just help me on this. I mean, you may give me exactly the same answer, and it may well be that there's absolutely no reason to distinguish. But if we look back at clause 3.4, look at walls. I mean, one might say, what is the point of a prohibition on the tenant cutting, maiming, altering or injuring any of the walls? Because surely a tenant doesn't have a right to do that anyway.
Well, it would do if it's part of the demise, because it would be then its property. So you have to control what the tenant can do, which is why you have the control on alterations. And not every lease is a structure demised. And so in that situation, then an alteration of a structural wall which is non-demised would be a trespass. But where you have a lease which does include part of the structure, as this lease does, and you can see that in the definition of the demise, because it includes, so the definition of the demise is page 64 in this lease. It's actually scheduled to the lease. page 64. So it includes half part of the depth, the structure between the floors. So that's why it's necessary to have some control on work done to structural parts of the building. Just to echo what the analysis, how Lord Justice Atkin expressed himself in Boswell and Crucible Steel, sorry. It's a similar expression in Lambourne and McClellan, sorry. Passage we've looked at, but page 274, again from the judgment of Lord Justice Vaughan Williams. In his use of the expression landlord's fixture, so it's page 274, halfway down. Having identified or classified the items as generally being described as landlord's fixtures. This is tab 9 of the authorities bundle.
Yes.
Or just as Vaughan Williams says, so they're all such as generally described as landlord's fixtures, and a few lines down, but I'm using the expression as means fixtures, which under the ordinary law, by reason of their attachment to the premises, the tenant would not be entitled to remove as against the landlord.
All right, but that's helpful, but I'm very much thinking aloud here, but does it follow from what you've been submitting that really clause 3.4 falls into two parts which have different purposes? There's the part of it about not making alterations or additions or cutting, maiming, altering, injuring any of the walls, timbers thereof, or altering the eternal arrangement thereof. Stop there. That's one part that has one purpose. Then there's or to remove any of the landlord's fixtures therefrom. And that's really a bit different, with a different purpose. Because the first part of is what you can do to the premises during the currency of the lease, whereas removal will cover, apart from anything else, what you can do on the expiry of the term.
Yes, but I mean, the lease obviously has no life beyond the expiry of its term, so both are within the parameters of its lifetime. I mean, a distinction might be this, which is that the first part is to prohibit things that you cannot do, prohibit things that you could do unless I controlled you by imposing a prohibition. Whereas the second thing is, well, giving you something. So the first part is taking something away. You would have a right to alter, but I'm going to say that you can't. And the second thing is, you wouldn't have a right to remove, but I'm going to give you a right. So if one's looking for a distinction between the two halves, one is restricting what would otherwise be a right, and one is actually conferring something that wouldn't otherwise be there. Because the removal would still, I mean, alteration and removal still operate and apply right up to the moment the lease comes to an end. There can't be any activity after the lease comes to an end, whether it's removal or alteration, because at that point it'd be a trespass, because there'd be no interest in land. So if one is striving to identify a distinction between the two, I think it's to do, my submission would be, it's to do with the rights, controlling rights and conferring rights. So, so in circumstances where one is construing a clause whereby the landlord is conferring a right, what my submission would be, you'd be looking at a narrow rather than a broader interpretation of the clause. What the effect of the clause is to give permission to take something away. So if one then thinks about its commercial context of the arrangement, the landlord is going to want some control over that. Because even if it's replaced, what was there is still taken away. There may have been there may have been a provision of a substitute, but it's not the same. So that's where you find the control. The control over replacement is in the qualified nature of the prohibition. And that's consistent with there being removal, irrespective of whether there is subsequently replacement. But in any event, I wouldn't accept and don't accept that the ordinary meaning of the verb to remove is taking away without replacement. Because you're not left with the same thing. The thing that was there has now been removed. Yeah, it said that, well, there needs to be flexibility for improvement, but I've addressed that. The improvement qualifies the consent. The consent cannot be unreasonably withheld. It's also consistent with that interpretation as removal, irrespective of whether there's replacement, is the absence of any provision for a qualitative measure of the replacement item. And that the absence of any measure of quality is consistent with the intention that replacement is irrelevant to the operation of the clause, because that assessment of quality comes in with the qualification of the prohibition. Because if the intention is for there to be a replacement, that will form part of the request, and there will be approval. There will be approval because consent is given, or there'll be directly, or there'll be constructive consent because consent has been unreasonably withheld. That's where you find the control over the quality of the substitute. That is consistent with its commercial context, because the landlord will be getting back the substitute, not the thing that it gave. As part of the exercise of interpretation of the verb to remove, my learned friend refers to renewal, or the verb to renew is used in the repairing covenant, and also to the use of the verb to replace in another clause in the lease, which we'll look at in a moment. Firstly, it's, as I understand it, it said, well, had it been the intention to prohibit a replacement or a renewal of the door, then that word would have been used. But the object of the clause goes wider than that, because it also is intended to prohibit removal without replacement. So reframing the clause in a different way wouldn't achieve the same objective. If it was a prohibition against renewal or prohibition against replacement, it wouldn't achieve the objective in the event of a removal without replacement. Unless it would be only this, I don't propose. Well, the other word that's looked at is the verb to replace, as used in one of the clauses of the landlord's obligations, which is in clause 5N of the lease, which is in supplemental bundle tab 5.
I mean, at the moment, it seems to me, you have on your side here the point. This is an absolutely commonplace English word, and on any view of the matter, taking away one front door and replacing it with another involves the removal of the one that's taken away. And I mean, that's the end of it.
But I won't press the argument any further.
Sorry, I mean, that at first blush at any rate, or indeed at second blush, unless one can find something in the context which narrows the concept of the verb to remove. But on the face of it, if something was part of the structure and is taken off its hinges and put in a skip or whatever happens to it, then it's been removed, regardless of what goes in its place.
Yes, my lord, and that's what I say is the ordinary meaning of the word.
Yeah.
I'll see how my learned friend puts it.
But you have a right to come back, of course, in reply, yes.
So, again, again, forgive me, I'm not saying this as a make weight, but there's the rival construction point as well. If one comes to alternative meanings, which is one more consistent with business sentence, the same considerations apply. So
yes, well, we have your written submissions on that.
Yes.
I mean, at the moment, as I say, it seems to me a really very simple argument based on the ordinary meaning of the word remove. And
Yes.
that may be all that needs to be said on it.
yes, unless I can assist you any further. Or any,
Thank you very much. No, well, thank you very much indeed, Mr. Fields End. So, Mr. Grant. Yes.
My Lords, it's not in dispute between my learned friend and I that this is predominantly an exercise in contractual interpretation. To answer one of the points that was put to my learned friend as to whether I submit we ignore or pay no attention to previous case law, I say no. It's my submission, in effect, certainly on this first point, or will be, that as I've set out in my skeleton in paragraph 17 and 18, there are some fairly workable tests for what constitutes a landlord's fixture, certainly as against what constitutes part and parcel of the realty, i.e. categories B and C in a lease stone. And it'll be my submission, at least, that that ordinary standard wording is enough, or ordinary tests are enough to capture the main entrance doors to the flat, which is where we are. That being the case, my Lords, I will then go on to submit and make good the proposition that nothing else in either the background evidence or provisions of the lease indicate that the landlord's fixture was intended to capture the front doors where it wouldn't ordinarily, and I'll look, as my learned friend has foreshadowed, at clauses 3, 4, and certainly as against 4, 1, both at their wording and what I say their purposes are. And I will deal there with some of the other points that have been made about the background of the lease. I'll then, my Lords, deal with some of the other points raised in criticism of His Honour Judge Bridge's decision. I don't think that will necessarily materially turn this case, which is primarily about interpretation, but I will deal with them, and then I will come on at the end to deal with repair and renew. If I may, therefore, my Lords, begin with grounds 1 and 2, what is meant by the language of a landlord's fixture. My learned friend has taken you both through Elite Stone and through, Elite Stone and Lambourne and, of course, Boswell. If I may make some preliminary points on Elite Stone, if we could please turn that up, my Lords. Tab 14.
Yes.
It was put, I think, by my Lord, Lord Justice Henderson, that in Elite Stone, Lord Lloyd, having outlined this threefold distinction, is then looking at effectively whether there is its category A or category C, the bungalow. My learned friend said that category B and C are effectively treated together throughout Elite Stone, and that's why we don't get consideration of what is effectively a fixture, where the line is between category B and category C. I agree that we don't get any detailed consideration of what is a fixture, as is what is against part and parcel of the realty, but I don't accept that throughout the entirety of the judgment, categories B and C are simply merged. Lord Lloyd very deliberately at page 691G outlines the threefold test. For category C, he specifically uses the term part and parcel of the land itself. And then when going on to refer to objects in category B and C, he just says treated as being part of the land itself. And it's that phrase part and parcel, that category C phrase, that we then see repeated at paragraph 691H immediately below when he's outlining the question. And at paragraph 693C, when he's discussing, at page 693, part C, he says, applying the analogy to the present case, the analogy from Holland and Hodgson. I don't doubt that when Mr. Morris's bungalow was built, as each of the timber frame walls were placed in position, they all became part of the structure, which was itself part and parcel of the land. So it's that part and parcel point is category C. I don't think that's necessarily a significant point given where we are, but I felt I had to point that out. That being the case, my lords, my first submission is that a fixture is not something which formed part and parcel of the original structure of the building. It might well be that there's actually not a great deal between my learned friend and I on the test, and the more is about the application of it, given the way it was put to you in oral submissions. I don't know, my lords, if there's any bet.
I mean, as I understand it, you don't take issue with the submission Mr. Field's made, that the test we get out of Boswell is whether it is part of the original structure. Where you differ from him, as you just said, is on the application of that test to the facts here.
Yes, my lord, that's right. Yeah. In that case, I don't suppose there's much good in going through Boswell again in detail.
Well, it never hurts to look again.
But if it would help, then my lord, we can more than happy to turn it up. Boswell, of course, is tab 11. And my lords may well have in mind, as I set out in my skeleton, then whilst we were just dealing with the test, that's my first point, part of the original structure. A slightly different way that I put it in my skeleton is no matter when something is affixed to the land, if it is integral, I think the phrase I use is integral to its use, but I'll just turn my skeleton so I'm not getting that wrong. If it's essential part of the building and therefore not an accessory to it.
Well, as I understand it, you rely really on the way it's put in the head note to Boswell. If we look at the head note, page 119, fixture means something that is affixed to the premises after the structure of the house is completed. It does not include things which form part of the original structure itself. So you say that's the test. If you apply that test to the present case, well, entrance doors are part of the original structure of the house. That's it in a nutshell, as I understand it.
Yes, my lord, and what's put in the head note is, I think, a good summary of certainly what's put in.
Well, of course.
Thanks. I know it's a head
One
note.
always has to be careful with
Well,
head
that's why I'm
notes.
not relying just on the head note, my lord. I'm happy to go through the judgment, if it would help. So if we may turn up then Lord Justice Banks at page 122, where he says, it is impossible to say that windows such as these forming part of the original structure of the house are landlord's fixtures. Lord Justice Scruton on the same page, again to the passage my learned friend has taken you to, the meaning of the term is well understood. I've always had a difficulty in understanding what is meant by landlord's fixtures. But at all events, it seems to me clear that the expression cannot include a thing which forms part of the original structure of the building. It must be regarded as confined to things which have been brought onto the house and affixed to the freehold after the structure is completed.
I mean, that's where the head note comes from, isn't it?
Exactly, my
Yes.
lord. Lord Justice not Atkins. The previous judgment we just looked at is also consistent with that, and then we get to Lord Justice Atkin, again, to the passage to which you've already been taken.
Yes.
Where he
Then something which has been affixed to the freehold, again, that implies it wasn't there from the start.
Exactly, as accessory to the house, and again, does not include things which were part of the house
In the course of its construction.
Absolutely. So my main point, my main submission, alongside my learned friend, is that the test is what is made part of the house in the course of its construction.
And of course, I mean, as a decision of the Court of Appeal, and I may say an extremely strong Court of Appeal, I mean, that is binding on us.
Yes, my lord. It is. It's also I submitted, frankly, an extremely workable test. The other, as I say, slight way of putting it, because that's referring to the original structure as put in the Court of Instruction. The other alternative that I put to my lords is, as I say, whether it's, even if it's brought on afterwards, if it becomes an essential part of the land and building so that it's not an accessory. Now, my lords, the authority for this is not quite as clear cut as the point in Boswell, and it really refers to, as I say, what's brought onto the land afterwards. I draw it from, starting with Boswell, the judgment of Atkin, Lord Justice Atkin, when it's the particular reference in the passage we've just looked at to something which has been affixed as an accessory to the house. And in my submission, that's a qualitatively different situation to if, for example, you were to bring, a tenant was to bring on a load of bricks and build another house, or, for example, on land or similar. So it's not solely whether it's, or one test is whether it's the original part of construction, and this is a second test as to if something else is brought onto the land, is it effectively being used as an accessory to what's already there, or is it something more fundamental? I appreciate that is just one judgment of the three in the Court of Appeal. On this same proposition, my lords, if I may perhaps then ask you to turn Climmy and Wood, which was has already been, my learned friends have already taken you to at tab 6. And again, this is rather unsurprisingly the same passage my lords have already looked at, in the judgment of Willis J at page 329. And this is his line in distinguishing, in effect, the almost three categories of items. So there's, as my learned friend has taken you to, he starts off by referring to things annexed to the land remaining chattels, and then continues, on the other hand, things may be made so completely a part of the land as being essential to its convenient use that even a tenant could not remove them. And an example of this class of chattel may be found in doors and windows. And then, of course, he goes on to deal with tenants' fixtures.
And again, this is a decision of the Court of Exchequer Chamber, which is presumably an appellate court, again, binding on us as a matter of precedent.
Yes, my lord, and given that it features Willis J, Keating J, Blackburn J, Brett,
Well, I mean,
Hayes,
8 of them, quite a list, yes.
Quite a strong court, to put it somewhat mildly, although it is, of course, the court itself, not those sitting in it, that I should be looking at. So I think my Lord Justice Henderson said that, again, this is a helpful, workable test in the course of his questioning for what is or should be considered a part and parcel of the realty as opposed to a fixture. And my Lord, I could put it no higher than to say that I submit that is correct. And the last authority, my lords, that I'd like to look at on this is one of the textbooks rather than any case law, and it's Dowding and Reynolds, the Delapsed Modern Law and Practice at tab 3. Internal page 594, paragraphs 2502 and 2503. Whilst it is certainly the majority of paragraph 2502 is citing from Boswell and then Elitestone, the way the authors put it is this. At 2502, an item affixed to the demised land or building, either in the course of its construction or afterwards, so as to become an integral part of it, is not a fixture. They contrast that, paragraph 2503, by saying that a fixture is anything which has been affixed to the demised land or building in such a way that it's lost its chattel nature, but it has not become an integral part of the land or building. The footnote there refers to paragraph 2506 and following. That's not in your final, my lords, on the basis that it goes on to effectively discuss the purpose of the elite stone type nature and purpose of annexation discussion, rather than the distinction between what we've been calling categories B and C. So, my lords, those are the three authorities I submit support my second way of looking at this. Now, I accept the criticism, certainly clearly, that my learned friend has put forward, that in Holland and Hodgson, they say it concerns, there's not any detailed consideration, effect, of what is a fixture. Forgive me, sorry, I'm finding the place. I accept that, but I submit that it's still, with respect, a workable test, and remains, certainly the court in Holland, it makes the point that we didn't consider what a fixture was, but it doesn't necessarily say they got it wrong, or that the jury got it wrong. So I submit, my lords, that that remains good authority for that proposition.
It is another way of looking at it to say that just precisely because it is a threefold classification which distinguishes between fixtures and something that is part of the building. I mean, if you look at and answer the question, is it part of the building, and answer it yes, then that's the end of it. Because
yes,
you don't need to go on to consider whether it's a fixture in any other or different sense.
Yes, ma'am.
And that's one of the purposes of distinguishing the two categories, is that very often the answer will be provided simply by applying what we might call the premises test, like the glass window.
Yes, my lord, I accept that. And I think it was certainly agreed before the Upper Tribunal. I think the reference is paragraph 44, but I can turn it up if necessary, that to be a landlord's fixture, something actually had to be a fixture. So if it's part and parcel of the building and not a fixture, then it's not a landlord's fixture. With that, against that background, my lords, I'll probably move on to where the meat of the distinction is between my learned friend and I, which is why I submit that an external door is part and part of the structure of the building, or integral to the use of the demised flat. Sorry, part and parcel of the structure of the flat. The field reference I outline some points in paragraph 19 of my skeleton, which I'll expand on now, and there are, I submit, really five key things we need to consider, and the first of those is the origin. Now, as I've submitted, a flat, the door, the external door, is part and parcel of a flat on its construction. I submit that you cannot really, when you're dealing certainly with a building like this, wherein there are a large number of flats and rooms, you cannot point to something and say it is a completed flat until it's got an external door. Otherwise, you've got a collection of rooms that are open to, physically, if not perhaps legally, everyone. A flat, by contrast, is a series of self-contained rooms, and if there's no front door, they're not self-contained. So my first point, my lord, is, frankly, that the door is affixed to the structure in the course of its construction. And it might help, my lords, forgive me, I probably should have addressed this earlier. When we're talking about structure, I submit it, we're not dealing with, for example, simply the load-bearing elements. We're dealing, in fact, with the material parts that you can look at and say that is a house, that is a flat, without which the demised premises in issue, whatever it may be, can't be said to be what it says it is.
I think we have a photo of the front door at the end of the...
Yes, there is at the very back, my lords, at tab...
myself what it looks like.
I think it's tab 11. Yes, tab 11 of the supplementary bond.
I mean, this shows, in fact, it's, so to speak, what one might call an internal front door. It's not one giving onto the street or anything like that.
No, my lord, it is an internal.
Because I can see there's a staircase to the right.
Yes.
So
Yes.
it's the division between the flat and the common parts.
Exactly.
Yes, my lord. It's a division between the flat and common parts. One of the points that you, my lords, may have picked up from a footnote in my skeleton is from one of the instructions to me. The instructions to me, there's no finding on this, so I'm not asking my lords to proceed on this basis, but the instructions they were given to me is that certainly in the 1970s and possibly the 90s, the door from the building to the outside was not in fact secured by a lock. Now, as I said, there's no evidence on this. I'm not asking you to make any decision on that basis. I'm simply, the point of my footnote, in which I simply repeat here, is certainly in today's day and age, we might automatically assume that the entrance between a building and the outside road would be secured by some sort of lock, and I simply ask the court not to proceed on that assumption, given that there's just no finding either way.
So just so as I've got that point, what you're submitting is that, particularly bearing in mind the vintage of the original leases, we have to allow for the possibility that at that time the block as a whole would have been open to the public.
Yes, my lord, if I may put it, if I may go so far as that.
You can't say that that was in fact the case,
No.
but the possibility has to be allowed for.
Yes, my lord, that's how I put it.
Yeah.
But yes, these
Yes.
are internal doors, i.e. between the flat and common parts such as the staircases.
This is, I take it, a purpose-built block of flats rather than a sort of conversion, is it? Or again, we have.
Might I check with the person behind me, my lord? I've not...
Well, perhaps I shouldn't ask. I mean, probably nothing turns on it. I've been assuming if it had 168 flats in it, or however many it is, it's
I understand that's the case, my lord, and I think
It
you're
is a
probably
purpose.
right, rather than a 168 flat conversion. From
well, that sounds implausible, particularly.
would be a very, very stately home in the heart of London to accommodate 168 flats.
But if it's the Walton Street I'm thinking of, I mean, it's near Harrods, it's in Knightsbridge, it's
Yes.
near South Kensington, so it's yeah.
So, my lords, that's my first point on why a door fits into the language of this, i.e. its origin. You cannot point to a constructed flat until it's got a front door. The second, my lord, is to consider how a door is fixed. Now, my lords, there are of course a great variety of doors one might come to consider. I don't think there are any detailed factual findings of the FTT on exactly how it's fixed, i.e. hinges and otherwise. The points that I'm simply making here is that a door, obviously it's fixed by hinges, but it also falls within the framework of there's usually a door frame. There is in fact an email in this bundle between Mr. Fivaz and Marlborough Knightsbridge saying that he had the frame physically reinforced for this door. Again, I don't think there's an FTT finding on that, but so I'm not asking you to necessarily proceed on that basis, but again, something for which perhaps allowance should be made. And my lords, for your note, that is page, I think it's 109 of the supplemental bundle. Yes, page 109 of the supplemental bundle is where he says that. And any sort of door frame is, of course, fixed to the walls. So there is an intrinsic link, my lord, when talking about certainly external door. I appreciate this may not go for internal doors, between the walls, the frame, and the door. And in my submission, they all form part of the skin of the house. The skin, of course, being the phrase used by in Boswell, by at least one of the judges whose name temporarily unfortunately escapes me. So that's my second point. My learned friend my third point is function. It provides, as I've said, security and privacy. As I've pointed out in my submission, a flat is really not a flat without a front door, and it is, my submission, essential to a flat's convenient use that you can shut the door and keep the world away. It's not an accessory to the flat. It doesn't make it just a bit nicer. It is, in my submission, essential to safeguarding and protecting yourself, your family, and in effect whoever else might be in this series of rooms with the building of many other people. although my learned friend said that it can still be used as a dwelling without a door, that you can get legal security even if not physical security. In my submission, that would be a triumph of legalism. We have to, in my submission, we should look at this somewhat more practically and consider what it is someone is practically contracting for when they are obtain a lease of a demise of a residential dwelling, and it is the ability to keep the world out of those rooms. And my lords, if a helpful comparison in my submission might be made if we look at, for example, points that my learned friend has put forward of other examples of fixtures. So, for example, sanitary apparatus. Now, if, for example, someone were to come in and take some sanitary apparatus away, it is, of course, a considerable inconvenience, one might say a nuisance, and, of course, you would want to get your toilet, your bath, whatever it is back. But if someone takes your front door, it really places the tenant in a difficult situation. What can he do? He can't leave the flat. He has to protect his belongings. He can call someone, of course, but effectively, if he wants to look after what he's storing in the flat, what he's trying to protect in the flat, he then has to stay. That rather reduces the point of having a dwelling, at least from which one might think being able to leave is quite an important part of having a dwelling. So my submission, my lords, those reading it should very much be considered part of the material parts, part of the structure of the dwelling as built, and if not part of the original structure, then still integral to the convenient use of the flat. And in my submission, my lords, this accords with case law and commentaries. Climmy we've been to and discussed already. Climmy, of course, is, as my learned friend said, cited by multiple textbooks, and most, of course, that's not necessarily an indication if this court considers it wrong to continue with bad law or wrong law. It does, in my submission, indicate that a practice has developed around that sort of understanding, and that should at least be borne in mind. The other authority to which I'd like to take my lords, is Aldridge of tab 2. Again, my learned friend has taken to it. I accept, as he said, that much of what it says is effectively premised on cases that we've already discussed. But if my lords have that, in my submission the key point is this very last line, or very last sentence, where after quoting Climmy, saying that an example of the class of chattel which may not be removed is doors and windows, it's the authors who go on to say it seems better to regard such items as not fixtures at all. Again, my lords, a textbook is a textbook. I don't for a second suggest it's anything like binding, but I do submit it's the views of the learned author authors are entitled to are persuasive, for want of a better word. So then, my lords, if we may come to Lambourne and McClellan, which my learned friend submits, is strong authority for the proposition that doors are doors are landlord's fixtures. My lords, you've been taken at page 269 to the covenant, so I don't propose to start there again. If we may pick up with the judgment of Vaughan Williams, or Justice Vaughan Williams, at page 273. In fact, over the page at page 274, my submission, as I put in my skeleton, and I'll come to in a moment, much of this is based on the adjustum generis application anyway. But my submission, even his statement that the enumerated lists up to the world shelves considered landlord's fixtures is not, I submit, persuasive. And the reason why is this. He goes on, as my learned friend has taken me to explain how he's using the expression landlord's fixtures, which are fixtures which under the ordinary law, by reason of their attachment to the premises, the tenant would not be entitled to remove as against his landlord. So that's the test he's applying. Then in the very next sentence, he says, of the articles described in the particular enumeration, I may say that although some of them might conceivably be in the nature of removable fixtures, there is not one which might not just as well be as an irremovable fixture. So my point, my lords, is that although he says it's landlord's fixtures, he does seem to be acknowledging that it could be landlord's fixtures, could be tenants' fixtures, but it's not a definitive statement that it is, in fact, a landlord's fixture. Now, that might not be considered overly helpful when the line we're dealing with is fixtures versus part and parcel of the realty, category B and C, but it does, I submit, at least somewhat undermine the point that this is a strong statement that doors are landlord's fixtures. And of course, my lords, so that is my point on that, and then my lords, as has already certainly as is discussed in my skeleton, largely this case seems in fact to return on the justum generis principle, and in my submission, it is not certainly strong authority, certainly not strong enough authority to sway the interpretation of a different lease at a different time of a demise flat rather than trying to remember if this is the incomplete messuage case. But my lords, I will leave Lambourne and McLennan there unless I can be of any more assistance on that particular case. So, my lords, those are my submissions on the natural and ordinary meaning of what one would ordinarily describe as a landlord's fixture, and why my submission of door falls out with that definition and is much more akin to part and parcel of the realty. Unless I can be of any more help on that linguistic point, I'm then going to come on to looking at the other provisions of the lease, and in particular comparing clause 3.4 to 4.1. So as my learned friends quite rightly said, landlord's fixtures isn't defined. We probably wouldn't be here if they were. But in my submission, the comparison between clauses 3.4 and 4.1 is particularly important. Now, doors in clause 4.1 might help if we can just have that open.
Could you just keep your voice up, Mr. Grant?
Sorry, my lord, yes.
It's slightly difficult to hear everything you're saying.
I apologise.
Thank you.
So yes, if we could please turn up clause 4.1.
Yes.
Now, in my submission, is Honourable Judge Bridge was quite right to note from the fact that doors features expressly in 4.1 and is contrasted with and all fixtures is an indicator that the door, certainly the external entrance door, is not to be considered a fixture. Certainly not at least a landlord's fixture. It does not say all other fixtures or the like, and it should not, in my submission, be read that way. Now, it's said against me that this clause should be considered to say all other fixtures on the basis that sanitary, water, gas apparatus are themselves fixtures, and reliance is placed on Lambourne. And I submit that's not right. So, my lords, first, Lambourne, as I've discussed, is distinguishable. But it is also important to note that this clause 4.1, also lists items that are clearly not fixtures. They're part and parcel of the realties, things like walls and things like ceilings. And indeed, there's very limited help we could even get if one wanted to get from the position of these various different items in this clause. Because some things, certainly the appellant claims to be fixtures, such as the entrance door, are positioned before these walls and ceilings, which are, I don't think, on any interpretation fixtures, whereas others, drain pipes, etc., come after. Now that would imply, if my learned friend is right, that parties might be considering things like walls and ceilings for fixtures, and I submit that's simply unlikely. It is a perfectly sensible reading, I submit, that the enumerated list is in fact listing what's present in the flat at the time of the demise, and what the parties don't consider, therefore, necessarily to be fixtures. So that all fixtures and additions, in fact, means precisely that. It's things that come afterwards, things that are thereafter affixed to the demise, or the, fixed to the demise. And in my submission, that makes sense. So taking, for example, some of the things that my learned friend has pointed to as examples of fixtures, things like drain pipes, wires, and cables, if they're placed within the walls, one might well consider them to be thought as part and parcel of the realty. Let's see. There's reference in the Dowding and Reynolds extract, which I took my lords earlier, to thermal insulation forming part and parcel of the realty. But it also would tally, I submit, with the Boswell point that things that are made part of the building or part of the structure of the building in the course of its construction are not fixtures. The parties could very well be looking at this thinking, all right, what's there? Here are your repairing obligations. And then ideas of fixtures and additions come afterwards to capture anything else that's added to the premises over the course of this 999-year lease. And I submit, my lords, if it's not a fixture, then it's certainly not a landlord's fixture.
Perhaps it's, I mean, some relevance here too. We're dealing with a lease, dated 1972. I mean, in a modern building today, walls and ceilings, particularly if they're sort of partitions or removable or sort of the kind of false ceiling which hides a whole lot of cabling and so on above it, there might be an argument for saying they're not part of the realty in quite the obvious sense in which most of us think of walls and ceilings in a sort of building of traditional construction. But given we're dealing with a building that was in situ by the early 1970s, I imagine it's that traditional type of construction which the lease would have, well, that we're concerned with.
Yes, my lord, again, that's one where all I can say is it's quite possible because I've not actually seen them.
No, but only it's a reasonable inference given we're dealing with a lease which was made 50 years ago.
Yes, my lord. It's also said against me, my lord, that clauses 3.4 and 4.1 simply adopt different ways of doing things. 4.1 adopts an enumerated list and 3.4 does not. But my lord, my simple submission on that is that must be taken to be a deliberate choice. And if 4.1 is interpreted as I submit it should be, then the absence of then the fact that there isn't the same enumerated list in 3.4 is not, in fact, decisive. And in fact, my lord, where there is intended to be duplication, it's there. Walls there are references to walls in both 4.1 and 3.4, I believe. Just double check I've not made that up. No. It is in fact in both. So where the drafter wanted duplication was there.
So, Grant, if I'm not sure I missed it. If sanitary ware apparatus, I suppose, is the word, isn't it? In this clause 4.1, if sanitary apparatus are landlord's fixtures, which I thought you said they were, but maybe I misunderstood, then doesn't that mean that whatever 4.1 means, it doesn't tell you, whatever the language about and all fixtures means, it doesn't tell you what is and isn't a landlord's fixture?
Forgive me, my lord, I wasn't conceding that sanitary apparatus are landlord's fixtures. I was using them as an example of what my learned friend maintains are landlord's fixtures.
Why aren't they landlord's fixtures?
My lord, there is an argument that if they were there as part of structure in the course of construction, they wouldn't be considered landlord fixtures. They're what's there, applying the Boswell point that I set out above, or previously.
Are you saying they're part of the structure? No, you're just saying that they're there already.
I'm suggesting, my lord, that there is a distinction between what this clause is doing, i.e. Listing, putting in an enumerated list what is there and what is part and parcel of the demise already at the time of drafting, and then questions of and other fixtures and additions is intended to capture anything that may be added to the premises thereafter. It's a temporal thing. It's a temporal distinction.
Yes, okay, thank you.
It's just turned 1 o'clock, Mr. Grant. So is that a convenient moment, or would you respond to you want to finish?
Yes,
off
my lord,
first?
that's a very convenient moment. I'm about to come on to the various purposes of the clause, so that's a good point to break.
Good. Thank you very much. In that case, we will continue at 2 o'clock.
Authorised?